Greetings, innovators and leaders. This is AI for the C-Suite, your compass for navigating the exponential age. I'm your host, Chad Harvey, and we're here to bring you cutting-edge insights on AI tailored specifically for middle market organizations. Buckle up as we embark on a journey through the transformative world of artificial intelligence. Today, I am delighted to welcome Emily Tait, an intellectual property partner at Jones Day who's at the forefront of AI's legal frontier. Emily brings over 20 years of experience advising clients on complex IP matters, including patent, copyright, and trade secret litigation. As co-leader of Jones Day's global working group on autonomous vehicles, artificial intelligence, and robotics, she helps clients navigate the novel legal challenges emerging from these rapidly evolving technologies. Emily's expertise is particularly valuable as we enter uncharted territory with AI and intellectual property law. Emily recently served as chair of the GenAI working group for the Michigan Judicial Council, helping judges understand the implications of this technology for their operations. What makes Emily's perspective especially valuable is her unique blend of legal expertise and technical knowledge. She's a registered patent attorney with an advanced degree in international IP law and specialized training in AI from MIT. In today's conversation, we'll discuss how AI is reshaping intellectual property law, what middle market companies need to know about copyright in the age of generative AI, and how legal frameworks are struggling to keep pace with technological innovation. Emily, welcome to AI for the C-Suite.
Well, thank you so much for your kind introduction and for inviting me to speak with you today. I'm excited about it.
So am I. And before we get started, I do need to make a disclaimer here to our listeners. Emily is here today speaking in her individual capacity, not on behalf of her law firm or her employer, Jones Day, and any views that she expresses are her own, and she is not giving legal advice or commenting on any particular matter or circumstance. Is that fair, Emily?
That is absolutely correct. Thank you for clarifying that. We always need to have disclaimers when we're lawyers talking, so I appreciate that.
Absolutely. Well, we want to make sure that folks don't go out and make any big, heavy business decisions based on what we talk about here today. So let's just jump right in. Copyright law, trademark law, and patent law are three distinct buckets, and they mean different things.
And trade secret.
Yeah, and trade secret. Yes, thank you. So maybe in 60 seconds or less, right, or as succinctly as possible, what are the differences between these four areas? Because I think that would be helpful for our listeners to know.
Yeah, so I mean, patents are, inventions, and they're things that if you come up with an invention, you have to go to the United States Patent and Trademark Office and seek to get protection over your invention, which basically gives you the right to exclude others from practicing that invention for a set period of time. Copyright is original expression of human authorship. So it can cover, novels, paintings, music, computer code that's written, but it's human original expression. Copyright exists upon fixation in a tangible medium, so you don't need to go anywhere to get that protection. If I paint a beautiful portrait in my office right now, I am the copyright holder, right? Provided I didn't copy it from someone else and it's original. So I don't need to go anywhere to have that protection, but I do need to get a copyright registration in the United States if I want to sue anyone for infringing my work. And copyright registration confers a number of other benefits as well, but it is generally needed to initiate a lawsuit. Trade secrets, that's a real interesting one. Trade secrets are a type of IP, and it really just covers a wide array of information, business information. You could have formulas, processes, even customer lists and other things like that, right? Trade secret is something that derives independent economic value by virtue of it not being generally known to others. And you can keep that for as long as you can, in other words, the right exists for as long as it's maintained as secret, in contrast to patent and copyright where there's limited term. Trade secrets are interesting because there's nothing in the law that says that a trade secret has to be created by a human. So unlike patent and copyright, trade secrets theoretically, right, could be developed by an AI or enhanced by an AI, But I think then the trick becomes, who's the human who knows what that is? How do you identify it? But again, yeah, trade secrets, really broad, can apply to a lot of things, and you don't need to go anywhere. You don't need to go to the patent office. You don't need to go to the copyright office, but you are going to need to identify them with a reasonable amount of specificity, and you're going to have to keep those, secret, or at least maintain them, reasonably maintain the secrecy of those in order to have protection. Probably the most famous example of a trade secret is the Coca-Cola formula. And then trademarks, are really brand identity. So, logos, names, things that are distinct source identifiers, right? So that the company can, reclaim the benefit of its good name in commerce, but it also has a function of identifying to consumers that when you're buying, you're going to McDonald's or you're going to Nike or you're buying a product, this is the source I'm getting it from. So that's kind of what trademarks are.
Perfect. I appreciate, I'm sure that was, rather basic for you, but it occurred to me as we were having this conversation, it would be good to just pause and kind of take a moment and explain these 4 categories here. And I listed 3, you appropriately threw in trade secrets. So thank you.
Oh yeah, certainly. And it's interesting because I think, if you're not an IP person, and even sometimes people who are, obviously very sophisticated business people, but they're not IP people. And so, hey, I need to patent this, but really it's maybe something that's more appropriate for trade secret protection or maybe even copyright protection. And so there's sometimes, just some baseline understandable confusion about these sort of different types of IP for sure.
When you and I had a prep call the other week, we talked about the Copyright Office and their recent issuance and their 3-bucket framework, what we call kind of the IP landscape in the AI context. And when we talked, you had mentioned that they'd broken down AI copyright issues into these 3 distinct buckets. So I think it would be great for our listeners if we could start there and you could kind of walk us through these 3 categories. Why do they even matter to businesses using AI today?
Yeah, so the U.S. Copyright Office has been really interested in AI for a number of years now and has done quite a bit in this space in terms of promulgating its own views on things, but also soliciting feedback and input from the public and various stakeholders who are kind of at the intersection of AI and copyright. And the sort of buckets I was talking about, really, the bucket is my term, not the Copyright Office's, but they are doing a really detailed report on AI and copyright, and they are introducing these concepts in 3 different parts. So the first part of the report was published at the end of July 2024, so just last year, and it was focused on digital replicas or deepfakes, as we often hear them called, and really focused in on surveying the landscape both on a federal level and on a state level, sort of what do we have related to deepfakes in terms of the law. And the office concluded that there really was an urgent need for federal legislation that address basically the unauthorized distribution of digital replicas that realistically but falsely depict an individual. So that was the focus of the first part of the report. And obviously, AI and GenAI have made the proliferation of deepfakes much easier, and therefore the threat is much more real. And then part 2 of the Copyright Office's report was actually published this year at the end of January. And that focused on the copyrightability of outputs, of GenAI outputs. And so obviously that's a hot topic because a lot of folks are starting to play around with these tools and, sort of this question of, well, can I protect it with copyright if I do this really cool thing with a GenAI tool? And so that's kind of part 2 where the Copyright Office waded into that. And then the final third part of this report is going to come out, we think, sometime this year, not exactly sure when, but that's going to be focusing on the legal implications of training AI models using copyrighted works as part of that training, and also licensing considerations, and also weighing in potentially on the allocation of potential liability. So all 3 of these parts of the report, kind of touch on really pressing, important, interesting issues. But I kind of like the way they've broken it up. It kind of presents these massive topics in sort of bite-sized pieces.
The interesting thing, well, there's a lot of interesting things, and we could probably spend the entire hour talking about this three bucket framework. I actually just saw a post on LinkedIn a few days ago for April 1st, April Fools, and the poster had put out there that there was an executive order and all copyright protection was being waived for training models. And there were 400 comments. I was just astounded how many folks looked at that and they're like, oh, yeah, this is great. We're going to just waive copyright protection, not understanding that this was an April Fool's post. And
Oh boy.
yeah, oh boy is right. And I think that goes to the heart of the tension here in terms of a lot of what's happening in, quote, the business world or the real world with these models and what our laws allow for. And I'd be very interested in knowing what you've experienced so far, especially with respect to the training models. So we'll maybe take this in reverse. So what have you seen out there in the world with companies that are looking to spin up their own models and the training data that they're using? Because I think that this is something that's going to really start to come to the fore in 25 and 26 as access to these different models becomes more democratized through platforms like Microsoft's Azure AI Foundry, Amazon Bedrock, et cetera, et cetera. So what can you speak to regarding that and what people should be thinking about with respect to the law and how they're viewing different training materials and training data?
Yeah, so that's a real tough one to say the least. There's so many layers to that question, but let me just start by saying that's wild that somebody posted that. I think it's a joke. It's quite concerning when stuff like that happens, because I think, yeah, a lot of folks might just see the headline and not really get the punchline that, oh, haha, that was a joke. And so that's kind of interesting. But I think it also relates to the fact that we're living in a time where obviously not only humans can generate headlines, but AI tools can as well. And so this need to sort of question what you're seeing and what you're reading, of course, is important. In terms of training data, obviously, this is, as I mentioned, the Copyright Office is going to wade into this in the third part of its report. But obviously, a big question right now has to do with, whether and to what extent a model can train on third-party copyrighted materials, as well as potentially uncopyrighted materials and data, things that are in the public domain, et cetera, right? But that question on the copyrighted materials and whether and to what extent the models can train on those without running afoul of our copyright laws. And there's a lot of litigation going on right now that's questioning that and raising that issue and bringing it to the forefront. I think, in terms of companies developing, different models, it's really a case-by-case thing. There isn't any bright line rules. There are companies that are developing their own models, and some of those companies are, going the route of getting quote unquote copyright clean materials, getting things that are licensed or otherwise, free to use. Other companies are perhaps taking a more bullish approach of saying, we feel that the building of this model truly falls within the fair use doctrine of the copyright law. So we don't think it's necessary to seek approvals to use this third-party content, copyrighted content, because, really the way in which we're using this data, along with all of the other data that our model may be training on, is really just to train the model to learn the English language and other languages, but sort of learn how to, quote, think like a human. So I think there's a big variation, and it really depends on the company and their model and their approach, their risk tolerance, their philosophy, how they're using their model, and so many other questions. There's not really a clean answer, but it certainly is an area where there are a lot of questions, and it's important to give that great thought if you, in fact, are developing a model or deploying one or using one, right? And understanding if you're using a third-party model, making sure you understand that model's terms and conditions and its philosophy and what are its guardrails and the other things that are in place, in terms of how you're using the model. So again, not an area where there's a lot of clean answers. There's more questions right now than there are answers, but it's certainly a hot topic.
Indeed. I'm interested as well, and I'll kind of step back. I know I drilled into the final part of that three bucket area that you outlined. I'm interested, out of all of these three areas, which of them do you see as creating the most immediate challenges for middle market companies? Is it the third one and that ambiguity regarding the training data? Is it the outputs? Is it the issue of deep fakes? Or what did you call it? Digital replicas. I love that term. So very soft. It sounds so much more approachable than deep fake.
Yeah, I mean, I think for any company, and certainly for a middle market company too, right? There could be challenges and really, and also opportunities, but challenges for any of these, sort of categories. And so, for example, I'm aware of instances where companies have had their executives or others affiliated with the company replicated in a way that is fraudulent, misleading, and damaging to the company. And there's a lot of concern about that sort of infiltrating their business, and a lot of questions about that. Other companies, on the training data, right, they may have questions about that if they're a company that's building their own model, or partnering up with a third party. There could be a lot of questions there if they're doing that. And then I think the issue of the copyrightability of outputs for companies that have a substantial IP portfolio, are looking to develop one. That question of, well, for generating something that if a human did it, it would be sort of copyright protected, copyrightable. What if we're using AI to do that? Or what if we're using AI to assist a human or human team to do that? So I think it really depends on the company, but all of these really are pressing issues, and I think evolving issues as well. So what might be at the forefront of a company's mind today, that might change as they look to the future and as this landscape changes. So it's not a static answer. It's one that I think all of these issues could be deeply impactful depending on the organization.
Mm-hmm. How heavily can we rely upon the traditional IP frameworks? Because AI is really challenging those. And to your point that you've raised in a variety of different ways here, I think that there's a lot of ambiguity, there's a lot of uncertainty. So where are some of the gaps that you're seeing as AI comes in to the legal system, which is notoriously slow to react to things?
Yeah, well, I mean, we right now we have to work within the frameworks that we have. And so what I think the challenges, right, are if you look at, patent, copyright, those are two types of IP that require a human creator. We have the US Constitution, the copyright clause, and it talks about essentially Congress having the authority to promote the progress in science and arts by essentially rewarding authors and inventors for a limited period, kind of this ability to exclude others from practicing their invention in the case of patents, or replicating their original work of expression in the case of copyright. And so our federal laws for patent and copyright, contemplate a human inventor in the case of patents and a human author in the case of copyright. So I think that that's an area where we see some real tension right away, because, obviously, anyone who's played around with a generative AI tool is likely wowed by what it can do, sort of with minimal human input. And also may have questions about, well, if I put something in, did I author it? If I put a prompt in, am I the author? Do I own that? Can I prevent others from using that output if I think it's really cool and I want to keep it for myself? And if I can't do that, then what do I need to do? And to satisfy sort of that human authorship requirement on the copyright side. And so those issues are also popping up in patenting of how much can a human inventor or inventors be assisted by AI technologies and still preserve the human inventorship requirement. So we know that these human author and human inventor requirements exist under copyright and patent law in the United States, but that does not foreclose AI assistance. So a lot of questions on that right now. And I think, it's made worse or in some ways made better, right? It's risks and opportunities, but the confusion is made worse by the fact that the capabilities of the technology seem to increase every day. And so, again, we're faced with these sort of new questions in the context of old legal frameworks, which obviously didn't contemplate the world we live in today, where GenAI tools can can do what they can do. So our law, recognized this bargain for exchange for humans, and not for robots, not for AI. So we're at this interesting point of analyzing these issues.
Mm-hmm. You said something here, and I don't want you to render a legal opinion. I'm very mindful of our disclaimer here, but you said something that kind of jogged my memory, and I recalled the invention of the automobile and how the automobile and internal combustion engine kind of arose in different areas, and there was some, I believe, some dispute historically about who actually invented the automobile. There were multiple, potential inventors. And as you're talking about the challenges here with respect to IP, patent law, copyright law, I'm thinking specifically about pharmaceutical companies, and I'm thinking about the research that they do. And as these models become more powerful, I think it's entirely possible that they could develop new drugs, new pharmaceutical formulations. And what happens if someone has an AI model that invents something, and someone else has a different AI model and maybe takes the same path or a different path and invents something simultaneously, right, independent of each other? How do we sort through that? Because that seems like an older IP question, right, if things arise in a similar time frame. But I would think that the new technology could allow for more of that to happen. Does that make sense?
Yeah, I mean, it certainly, the question makes sense. I think the answer likely at this point doesn't make a lot of sense, other than to say that I agree with you. I think that is sort of the future that we're moving towards. We know with human inventors, as with the example you gave with the automobile and obviously many others, right? There's often many humans who are working to solve a really difficult issue that has plagued scientists or engineers for a long time, right? And so you can have disputes among humans as to who did it first and all of those issues, which are really complex. And then you throw on top of it the capability of an AI system, perhaps doing it on its own. We know that under the current framework, an AI system doing it on its own without a human who is sufficiently contributing to the invention, right? An AI doing it on its own under our current regime, whatever that invention is, it's not patent protectable without the human inventor. And so then the question, that raises all sorts of questions too, right? Because again, we know humans can be assisted by AIs, but we also know that AI can do things on its own, and I think increasingly will be able to. And so that issue of ownership, I think, will be significant. There was actually a case involving a technologist who developed an AI tool and on his patent application listed the AI tool as the patent inventor and himself as essentially the owner, idea being I own and develop the AI, so I own this invention that the AI did on its own. And that was rejected as not meeting the human inventorship requirement. In that case, the applicant was sort of pushing the boundary there and trying to pressure test this. He didn't indicate, no, I really did it with the assistance of AI. He was really challenging this concept and saying, no, the AI did it. The AI invented this. And without that human inventor, that was not eligible for patent protection in the United States.
Interesting. So they are drawing a line with respect to the level of human involvement. Not even the level, I guess they're just saying you have to have human involvement.
There has to be human involvement currently. But there is no rule at all that says that AI can't assist and that other technologies can't assist. And I think in some cases it probably is a more clear-cut, example where the patent office or the copyright office can say, yeah, that satisfies, this human inventor or human author requirement. But I think I would expect there's going to just be a lot of gray area as the technology continues to grow and, sort of parsing out the human contribution and really identifying that. I think will be, it'll be challenging. It just seems like the brave new world is here and it continues, to change before our eyes. So I just think these questions and really challenges, but also really like eye-popping opportunities are just going to continue to grow.
Mm-hmm. I think you're spot on with that. So I would imagine you will have a lot of work in the coming decades here. No shortage of it.
Unless they replace lawyers with
I'm sure someone at Westlaw or LexisNexis is working hard on that right now.
exactly.
Let's drill in a little bit more to the human ownership piece and more specifically the issue of AI outputs. And I know that when we spoke before, we talked a bit about how people incorrectly assume that if I put it in, I own it, right, when it comes to an AI output. Talk a little bit more about how this relates to the human authorship concept in copyright law. I know we covered this, but I'm more interested, even than the legal principles, in some tangible examples that you could give us where maybe the Copyright Office maybe denied the registration of a work or something like that beyond what we just covered. So let's just unpack that, because I think a lot of folks out there still have confusion about that. And this was one of those things that I definitely wanted to make sure that we covered thoroughly here today.
Yeah. Well, so it's interesting. I mean, I kind of going back to just the basics, right? So copyright law doesn't, you can't get a copyright on a great idea. I mean, I could sit here and say, I have this image for this beautiful portrait, and it will, it'll be the city of Detroit where I live, and it'll have these beautiful embellishments, and it'll have this gorgeous sunset in the background, and it'll have this, that, and the other. And the reality is that's a great idea, but if I'm not an artist who can create that, me thinking about it, right, that doesn't create the right. In the same way that we all can have the great idea that curing cancer would be a marvelous thing, but many people have had that idea, and actually doing it as an inventor is a very different matter. So I think sometimes just thinking of it in terms of the idea, right? And so for the Copyright Office, in that second part of the report I mentioned that focused on the copyrightability of outputs, they kind of waded into this territory and gave an example of sort of a detailed prompt, right? And gave a great example. It was a pretty detailed prompt describing, a cat, smoking a pipe and wearing glasses and a lot of other details. And then actually the report shows this output. They cut and paste to put the output in the report. And lo and behold, it is just that. It's a cat smoking, in glasses. And basically the Copyright Office gave that as an example of something where the human who inputted that prompt, did not adequately determine the expressive elements that were ultimately produced, and didn't control, the expression ultimately. It was more like an idea. And one of the interesting things that the office pointed out there, right, is that when you looked a little closer at the cat, I mean, first of all, they point out the breed of the cat and the color of the cat wasn't selected, and those kind of things. But also there was a quirky thing, and this sometimes happens, and maybe some of the listeners have had this happen with GenAI tools, but there was a quirky thing where if you look closely, you just happen to notice that the cat's hand was a human hand. And it was sort of this odd thing, but the point from the office is that this output really was the AI tool kind of working its magic in response to the idea or the prompt that was inputted by a human there. And so that was an example of something that was not deemed to be copyrightable. It had insufficient human authorship. The office, though, did note that there could come a time when prompts could sufficiently control expressive elements, such that the AI generated output does indeed reflect human authorship, right? So the office was almost recognizing that the technology may change, the tools may change, right? The other thing that the office noted is there could be examples where you use like an expressive input. So let's say I paint something or I draw something, and that drawing would satisfy the copyrightability standard for sort of original expression. And then I inputted that into the tool and sought various enhancements to my work. That's an example of an expressive input where the input itself is, sort of satisfying the copyright standard. And that could be a scenario where the output, where that original human expression is in the output, and it's been enhanced by the AI tool. And that was an example of something that may very well satisfy the human authorship requirement, because it was showing, that the human being had sort of control over the expressive elements. But, the office also just pointed out that it's very case by case. There's no like bright line rules. But the one takeaway really is that there has to be sufficient human authorship, and that typically it's not going to be satisfied where the human is just simply inputted a prompt and there's an output that flows from that. Like as a general rule, that's not going to be enough.
Mm-hmm. As you're speaking, all I see are shades of gray, right, with everything that you've painted, because you talked about an expressive input that serves as the genesis for the final product based on prompting. I wonder what level of human involvement is necessary if I just put a prompt in, got an output, and then I amend that. You know, if, say, I get that image and then I start to work on it and tweak it myself. So many gray areas. It's fascinating, but I think it's going to be maddening for a lot of people.
Yeah, I think that's exactly right. And by the way, you had asked specifically examples that the office has faced. And the individual I mentioned, in the patent context, to sort of push the envelope by listing the AI system as the inventor. He also sought to do that in a copyright context and submitted a work, a visual image that, had he done it as a human, would have satisfied, the standards for original expression. But on the application listed his AI tool as the author, and again, himself as sort of the owner. And the Copyright Office also rejected that. Now, in that case, he didn't say, no, it was me as the human doing it, and the AI was altering it or enhancing it. It was kind of pushing the envelope and saying, no, the AI did this, and I think the law should protect this. But that was something that ultimately was rejected by the Copyright Office as not satisfying the human authorship requirement. And that finding was affirmed by the district court and the appellate court that considered the issue as well. So that's an example. But now there was another case where the Copyright Office there was a graphic novel where the images of the graphic novel were generated entirely using a generative AI tool, but the text that accompanied those images was written by a human author. And then the human had arranged, both the images and the text into a resulting, work. And there was protection for the compilation, right? The ultimate compilation was protected by copyright. The words that were written by a human being were protected by copyright, but the images in isolation wouldn't have satisfied the human authorship requirement because those were generated they were substantially generated by AI and not deemed to satisfy the human authorship requirement. So those images were not, but then, as I said, the compilation was and the text was as well.
Let's drill in specifically, because I did say I wanted to talk a little bit about the issue of creativity and more specifically copyright law. We've seen an awful lot of headlines out there with creators, different artists, authors, content creators, and they're making lots of allegations. I think the New York Times made some very famous allegations with their suit that their works are being used and copied to train the AI models and that this is copyright infringement. So some are defending it as fair use, and they're comparing it to somebody that's kind of walked through a museum, if you will, and they've learned from different sources and they're coming up with their own creation because of that inspiration. I think it's worth unpacking this a little bit. And I know we talked about copyright law earlier in our conversation, but this is kind of a nuance in terms of fair use. And maybe unpack that concept of fair use for us a little bit and then talk about what all this means right now.
Yeah, well, certainly there are a lot of headlines. I think there are, dozens of lawsuits that are currently pending. And I think, they're very interesting. And I'm guessing people have heard of a lot of them, right? Involving very famous actors and authors. And as you mentioned, the New York Times and others. And essentially, I mean, these lawsuits are all, they have some common threads, but they also have their differences factually. But the gist of these, I mean, I think there's basically two key arguments that are being made on the plaintiff side, where you've got the rights holders, the content creators who are objecting, right? They're saying generally, copying my work as part of your training model is copyright infringement. You're training the model, but training means you've copied the work into your model without my permission, without paying me. And that's copyright infringement. You directly copied it, and that constitutes copyright infringement. Some of the lawsuits are also alleging, and again, this really just depends on the case, but some of the lawsuits are saying also that, the outputs of the GenAI are also constituting copyright infringement. So in some cases, the complaints have cited examples where a user has said, hey, I'm being paywalled out of this article. Can you provide it? Can you provide a really detailed summary? Can you give me the first couple paragraphs? And kind of having these sort of gotcha allegations. So again, there's kind of these two forms of infringement that seem to be coming up in most of these. One is just sort of that initial act of copying where the plaintiffs are alleging that's copyright infringement. It's in the training data, full stop. And then some of them also saying, and oh, by the way, I have an output here that is infringing my work. It's providing a substitute for my work that somebody might have paid for. And then in terms of, you asked about fair use, fair use is a really well-established doctrine under US copyright law. And the idea, right, is there's basically four factors where, in other words, you can use copyrighted materials as long as it's fair. And what does that mean? And that looks at the purpose and character of the use. It looks at the nature of the copyrighted work. The idea there is, using, let's say, a novel or a portrait, that might have more sort of originality than a compilation of facts. It's very dependent, right? But not all works are created equally. So it looks at the nature of the work. Amount and substantiality of the portion of the work used, right? So somebody who quotes from something and cites it and does so in a way that's attributing and crediting that author, that in general, that's a small amount versus somebody who's like, hey, I want to do a presentation on this book. And so I copied the first 4 chapters, right? So looks at that. And then also, and importantly, the final factor is, what is the effect of the use on the potential market or the actual market for the copyrighted work? And so that's an important factor as well, because if you're competing in completely different market channels, that's a factor that will likely weigh in favor of fair use. Fair use is like notoriously super fact intensive and really hard to identify certainty. In fact, there was a famous case that went to the US Supreme Court involving a work by Andy Warhol. And what was interesting there was that the majority opinion and the dissenting opinion were just vigorously opposed from 2 justices who are often aligned, Justice Sotomayor and Justice Kagan, with the majority written by Justice Sotomayor saying that the use at issue was not fair and not sort of transformative, and the dissenting opinion reaching the opposite conclusion. So really intelligent, informed people can arrive at very different conclusions, and that further complicates the fair use analysis. So it's very fact intensive. In addition to the 4 factors I mentioned, courts can also consider other factors. They're not constrained to those 4 factors. And, it really varies by case in terms of how the courts are assessing that.
You threw out a phrase there that I had to smile. You said, identify certainty. And I thought to myself, boy, I'd love to be able to identify certainty in any context. That seems like a tall order, especially when we're talking about legal barriers here. Yeah.
No, it is. And I mean, the fair use stuff is really tough. And I mean, obviously, with the example you gave about walking through a museum, some commentators and others that are more on the side of the defendants in these copyright cases, will say, look, the way in which the works are being used as part of the training, you can analogize to a human who walks through a museum, is inspired by all the art, learns from that art, and then goes out and does something completely different, right? And so a lot of these lawsuits are kind of that argument's being made, like, look, these models are completely different than this little tiny work that's in the midst of this massive training data. All that training data is helping train the model understand how the English language works and to do its own thing. And so this concept of it's transformative, it's completely different. It's not meant to compete in the same channels, et cetera, et cetera. And so I think that, again, is really dependent on the facts at issue in each dispute. But that's sort of the theme you're seeing is like, come on, this is fair use. That's a key defense in these cases.
It's so funny. Sometimes I don't know where my mind's going to go during these conversations, which is unfair for the guest. But as you're sitting here talking about this, I'm thinking tonight I actually have tickets to go see one of my favorite sci-fi authors at a book signing, John Scalzi, and he wrote a book called Red Shirts. And if anybody's familiar with Star Trek, when Kirk and Scotty and all those beam down to a planet, they always take a couple security personnel with them, and they're wearing red shirts. And inevitably, they don't all come back, right? So there's this idea in the sci-fi community that the red shirt is it's a trope for kind of a disposable actor. And Scalzi wrote a book called Red Shirts, appropriately enough. And as you're talking and kind of unpacking fair use and some of these other concepts, I'm thinking about his inspiration for that book title and kind of how that all laid out there. And so just, I don't know that I've got a point or a question, but it just kind of struck me as funny with the timing of something I'm doing this evening. So.
Yeah, well, I mean, certainly a lot of these sci-fi writers envisioned the world that we're currently living in, and also, had some, catastrophizing about where things could go. And I think it is interesting. I mean, we are living in this very strange and disruptive time where it does sometimes feel like science fiction. And I do think when you play around with the tools and you see different use cases, it is it's eye-popping, to say the very least. And it just seems like new tools are being introduced every day. And it seems very much like it can't possibly be the now, but this is the world we're living in. So yeah, that's interesting.
Yeah. Well, and I think that's a perfect segue to something that I wanted to ask you about when we were having our prep call for this recording session. You talked about, and I wrote this down because I love the phrase, you said that AI moves, quote, light years quicker than a human lawyer or a politician can. And I thought that was just spot on. And because of that speed, I think that there's a mismatch out there. And I'm interested in your opinion or your thoughts here about the most significant ways that this speed mismatch is creating challenges for businesses that are trying to navigate IP considerations. Because just like that copyright office ruling that we were talking about earlier, the legal system is very far behind where the tools are. So maybe you could speak to that a little bit.
Yeah, I think it's just interesting. Every day, there are questions coming up about how to, how do we follow what's going on, and how, and that's from everybody, and it's like from judges, from fellow lawyers, from businesses that are struggling with the issue of just like, how do we keep up? And I've talked to folks who are really, really well versed in this. They're technologists, they developed AI, they have advanced degrees in AI, and usually the answer is it's impossible to completely keep up. It's too much. So I think one thing that's helpful is maybe identifying key areas of priority within any organization, as far as what are the key things we do just need to prioritize from an IP standpoint. Because I think that's sometimes half the battle of like, what is our portfolio? What are our key priorities? And then trying to align that with, the greatest potential upsides as well as the potential risks associated with, Gen AI, and being thoughtful about it. And sometimes in this fast and furious frenzy of information and change, having just giving a moment to actually strategize and give human thought to this is really important, because it really can be overwhelming. And in addition to all the changes and challenges and disputes and uncertainty with a lot of the IP stuff, there's of course, a lot of potential regulatory change and potential new laws that are coming onto the scene. So there's this feeling of, wow, this technology is pressure testing existing legal frameworks, but it may also lead to entirely new laws that we have to grapple with. So, I mean, just as examples, we talked earlier about deepfakes or digital replica. There's quite a bit of state level legislative effort to address sort of the name, image, and likeness and voice spoofing that deepfakes can present. And as I mentioned, the Copyright Office has urged federal legislation on that level. So there's these new laws that are popping up. There are laws on the data privacy and security relating, just as an example, to biometric data. So personal identifying information and legal obligations that are inherent in how companies need to manage that data, while balancing those obligations against their use of AI technologies that may potentially use that kind of data or desire to use it. So it's very complicated, and I think every organization is just different in terms of what does their portfolio look like, what does their data look like, what do their challenges look like, and at the same time, where do they think there's big opportunity by some of this technology? And so I just having a thoughtful approach to that, and sometimes just taking a moment to really dedicate resources and thought to it is a really important first step.
Mm-hmm. I couldn't agree more. And I know that you've spent some time working on issues like this for the Michigan Judicial Council. And instead of drilling a little bit further into your answer there, maybe this is an opportunity for us to kind of segue into what the broader thoughts in the legal community are. And I think you were actually the chair of the GenAI working group for the Michigan Judicial Council, correct?
Yeah, I co-chaired it with a judge here in Michigan, and it was great. I mean, it was the GenAI working group for, as you said, the Michigan Judicial Council, and so the group brought together judges from across the state, as well as other stakeholders, outside lawyers, folks that work for the government and otherwise. And it was sort of a think tank to discuss, certainly the risks of GenAI, but also opportunities, and in particular opportunities that could enhance access to justice and create efficiencies for the courts, right? So how can we use this tool for good, which is a really important question, but also the risks. And I think for a lot of the participants in the group, there was different levels of comfort, of course, with the technology and familiarity. So some people on the committee were initially just very worried about it, right? Because they saw headlines. There was a lawyer who infamously filed a brief that had been written by ChatGPT, and there was hallucinated case sites in that brief. And, obviously that gave a lot of the judges in the group heartache, especially judges who don't necessarily have the benefit of multiple clerks who can scrutinize everything. So I think there's a lot of concern about, wow, how do we make sure that lawyers are still adhering to their professional responsibilities as officers of the court and don't abuse these tools? At the same time, there were also, points being made that some of these tools were just an incredible gift to, for example, people who don't speak English as a first language, the translation capabilities, the ability to take, even for people who do speak English as a first language, trying to translate complex legal jargon into bite-sized pieces that give people the gist of what's being said. And so I think this sense of that could be a real tool to enhance access to justice, to help people, to increase efficiency of the court and its operations, was thought to be a really significant possible upside. But also learning how to navigate those upsides without falling into a universe where we're dealing with hallucinations or where the law sort of loses its human touch. And interestingly, at the end of 2023, Chief Justice Roberts of the U.S. Supreme Court did a year-end report on the federal judiciary, where he identified artificial intelligence as the topic that he wished to discuss as being a topic that was going to impact, the federal courts and judges and lawyers. And it's a really interesting read, coming obviously from, the nation's highest court, that I think really underscores, how impactful this is on the legal profession. And actually, the Chief Justice in the report sort of pointed out that the law is, notoriously averse to change, and cites the fact that, at the court, there's these quill feather pens that are still provided to advocates as sort of a throwback, and lawyers are not known for being the most embracing of technologies. And so, he kind of points that out, but also emphasizes that in embracing technology and going into the future and focusing on things like access to justice, it's essential that judges obviously maintain their impartiality and their human judgment, their human insight in assessing the disputes before them. So definitely my work on the Judicial Council was a lot of fun. It was so great to work with other people. I mean, just really smart and thoughtful people who are trying to do right by this changing landscape. And, fundamentally the judges who are very obviously committed to doing the right thing. And so it was a great experience. And I do think courts across the country are really grappling with these issues. So it's sort of a thing that is certainly not limited to Michigan, but it was great that Michigan that we did this and dedicated the resources to doing it, but other courts are doing it as well. And so I think that education and just involvement of the judges and lawyers to kind of have discussions is really important going forward.
I mentioned earlier in our conversation that sometimes ideas pop in my head and I ask unfair questions. So if this question is unfair, please flag me.
Okay.
As you were speaking, though, I was reminded of a warning that I started giving to folks several years ago with respect to marketing materials in terms of the sheer volume of content that was going to be generated by AI. And as you were speaking about enhanced access to justice and the impact of AI on the court system, it occurred to me, and I hadn't had this thought before, there's a very real possibility here that the democratization effect of these tools will enable a lot of people to file different legal challenges that maybe they otherwise wouldn't have contemplated. And I'm wondering whether an increased volume of filings was ever part of the discussion as part of your working group there, and is that a concern at all?
Yeah, it seems like everything has, it's like a double-edged sword,
Yeah.
right? Because you can imagine that potentially somebody could file things that they were incapable of filing previously or unable to for whatever reason. But there's also hope that there could be a reduction in filings if efficiencies are attained and issues can be addressed right off the bat. I don't think I'm not aware of any data yet that shows that happening. And I do think that ultimately, right, filings are still going to be constrained by the reality that most people who are initiating a complex dispute in court are going to need counsel. Very difficult to navigate that without counsel in a complex dispute, certainly. And so I think that there's that constraint of, can I hire a lawyer and pay for them to advance this thing that I want to file? So I think that's always going to be constraint on the number of filings. But I think that it's possible that it could lead to increased filings. I don't know at this point that there's any data showing that it's doing that already, but I think it'll be really interesting to see, right, that if these tools get to the point where they can meaningfully assist people in identifying their rights and potential remedies, and if that leads to an uptick. I think it's kind of anyone's guess at this point. Although somebody might have a better guess than me, but I just don't know at this point.
Yeah. Well, I think the key word there is guess, and we've all got a lot of guesses and a lot of opinions about what's coming next, and some of us will be right and some of us won't.
Yeah, absolutely.
That's the fascinating part about living in the age that we're in. Emily, this has been an absolutely fascinating conversation, and we're kind of bumping up on the self-imposed time limit that I usually set for these episodes. So I'm wondering if maybe we could end with a question to you about strategic positioning for middle market organizations and maybe some practical advice for folks. So what are some actions that you would recommend that leaders take today to position their companies advantageously as we talk about the intersection of AI and IP, again, artificial intelligence and intellectual property for our listeners? So are there actions that you would recommend that folks undertake, or maybe things that they can do right now to not necessarily future-proof, but give them a little bit of an advantage here?
Yeah, and I mean, unfortunately, this is also a very much like it depends kind of answer, just because every organization is so different. And so I think, but I do think just like painting in broad strokes, like at a high level, well, there's big variation amongst companies as to whether they've even thought about the implications of AI, Gen AI on their IP offerings. So I think it really, that's a preliminary question of, have we thought about this? I know a lot of companies have questioned, like, what do we do about these tools in our workforce? that's sort of a fundamental question, right? If these tools, which tools from your organization are your employees using? Are your employees informed as to the tools they're using? Are there tools that have been vetted and approved by your organization for employee use and third-party contractor use? And the answer to that question varies widely. Some companies may say, I think actually a lot we're grappling with this right when ChatGPT was first publicly launched at the end of November 2022. Wow, these tools are going to make it to our workforce. What do we need to do to make sure they're using the tools in a way that's legal and ethical and compliant with law and our policies? But I think it's still worth that initial question is really important, right? Because there could be tools that the company approves and the company expressly disapproves. So in the realm of trade secrets, for example, there are tools that have guardrails or appropriate safety mechanisms in place where company sensitive information could be appropriately inputted. But that is not the case for a lot of public tools, right? And by inputting sensitive information, you may disclose the trade secret and therefore lose the protection. So understanding the tool is really important. And I think, for depending on the company, another important question, right? So there's this issue of employee use and third-party contractor use, and what do we organizationally want our employees to be doing? And then I think there's a need to sort of survey the lay of the land of like IP portfolio, right? Because companies really differ on that. Some companies are really patent heavy. Other companies are more they create a lot of expressive content, and copyright may be a bigger issue. Other companies may have a combination, or maybe they're trade secret heavy, but also do some, patent work and copyright work. So I think understanding the company and what the IP portfolio looks like and what it might look like in the future are really important first steps in navigating things. And then once the answer to those questions has been reached, or at least partially reached, then kind of considering how do we anticipate using these tools? I've seen a real variation, companies that are really embracing the tools as a way to enhance IP offerings, and companies that are really resistant to doing that, in view of the human creator requirements, really grappling with this, not quite ready to embrace the tools to enhance innovation. So that's sort of a company, call it risk tolerance or risk philosophy. There's no one right or wrong way, right, to do things. But I think thinking about those issues is a really important first step. And again, just because things are so overwhelming, I've heard from a lot of folks who are in-house at companies working as lawyers in companies, and they're like, my job was already really demanding, and suddenly now I've been tasked with figuring out what's going on with AI and GenAI. And that's just been dumped on my lap. And so it's it's a hugely burdensome and stressful area, especially if somebody hasn't had grounding in it, because it just seems so new. It's changing. How do I wrap my arms around this? So in those situations, if you have like one lawyer doing it, that can present unique challenges versus like an in-house legal team. But it just really varies. I think at a minimum, though, thinking about the tools that are being used or that the company would like to use, and what the terms and conditions of those tools are, and what's the appropriate use of those tools by company personnel. Obviously, that's an important overarching consideration. And then giving thought to, the IP portfolio offerings, and giving some thought to that, those are threshold issues that I think are really important going forward.
I appreciate the thoughtfulness of your answer, and even more than that, I appreciate the business practicalities that you just outlined there. I think, look, I spend a lot of time working with different attorneys, with clients of mine in the M&A space and the IP space, and the real good ones are the ones that are able to boil these concepts down into simple, practical, actionable steps for their clients. So what I heard there was that if you're not thinking about these things, you probably need to call somebody like Emily. So thank you for that answer. And as we wrap up here today, for our listeners that do want to call you and want to learn more about your work, get in touch with you and your firm, what is the best way for them to do that?
I think the best way to do it is just looking me up on the firm website, shoot an email, or giving me a call. I'd be happy to chat with folks. It's just such a fun and interesting space. I just love hearing from people, even if it's not, a big piece of work, which of course is a great thing, but just really talking shop about it, I think is really a great use. Certainly in my time, I always enjoy it. I'm always blown away to hear what companies are doing with their IP offerings, and also just tools they've explored. It's just such an interesting topic, and it's changing all the time. And so I've never had a conversation with someone in this space where I leave not having learned something. And usually I'm not only learning something, but my head is exploding over something really incredible that someone has shared with me, or just an incredible use case, or some type of, you don't want to hear about it, but like an egregious misuse and bad things happening are obviously not what you want to hear about, but those are also good cautionary tales. But usually it's the good stuff, and I really enjoy it. And that with the work on the GenAI committee for the Michigan Judicial Council was a great example of that, because every week, you talk and just be really excited to hear from people. So I'd love to talk to folks and keep the conversation going. It's great fun, as it was today, talking to you, Chad. So I really appreciate it.
Absolutely. And just for our listeners that aren't looking at a screen here, the website for your firm is?
jonesday.com. I'm Emily Tait. You can look me up. I'm on LinkedIn as well. So yeah, feel free to give a shout.
Perfect. Well, thank you so much for your time today. I would love to have you back. The way things change so rapidly, we could be talking about a very different type of AI 3-6 months from now. So maybe we need to schedule another conversation for later this year.
Yeah, that sounds great. I know it's changing so much. I mean, the technology is changing, the law is changing, the regulatory landscape's changing. And I mean, this is to say nothing of the global aspects of it, which are also changing, and they vary by jurisdiction. So it's definitely not the kind of thing like we have one conversation and then we're done. We could have talked about any of the topics that we discussed today for hours, much less touching on all of them within a single hour. So
I know. Hopefully it didn't feel too rushed. So
no, it didn't. I enjoyed it.
Oh, good. Well, and this would be the time where I need to remind our listeners again that Emily was here today speaking in her individual capacity, not in her capacity on behalf of her law firm, Jones Day. The views that she expressed are her own, and she is not giving any legal advice or commenting on a particular matter or circumstance. Does that about cover it, Emily?
It does indeed. Yes. Thank you.
I appreciate your time, and also for our listeners, I appreciate you tuning in. Thank you for tuning in once again to AI for the C-Suite, where we're committed to helping middle market leaders thrive in the exponential age. So if you found value in today's discussion, be sure to subscribe to our podcast, follow us on all the socials, and visit our site, aiforthecsuite.com. Join us next time as we continue to unlock the potential of AI for your organization. And until then, keep your algorithms running, your leadership evolving, and your AI in check. Thanks, everybody.